Malaysia's drug situation has deteriorated in recent years, owing mostly to an increase in the supply of methamphetamine and heroin. The growing degree of drug trafficking across Malaysia by international drug trafficking syndicates (IDTS) is causing grave worry. This is reflected in the rise of foreigners detained in Malaysia for drug trafficking, including Indonesian, Myanmar, Philippines, Thai, and Vietnamese. The meaning of dangerous drug is under Section 2 of the Dangerous Drugs Act 1952 as any drug or substance which comes under the first schedule of the Act. Provision and drug trafficking can be seen in the Section 39B Dangerous Drug Act 1952, where the subsection 1 said that no person shall, on his own behalf or on behalf of any other person, whether or not such other person is in Malaysia, which paragraph A, traffic in a dangerous drug, paragraph B, offer to traffic in a dangerous drug, or paragraph C, do or offer to do an act preparatory to or for the purpose of trafficking in a dangerous drug. Any person who contravenes any of the provisions of subsection 1 shall be guilty of an offence against this act and shall be punished on conviction with death.
To prove drug trafficking in Malaysia, the burden is on the prosecution. The prosecution need to prove the ingredients of the offence. There are 4 ingredients of the offence. The first one is the drug or substance must be a dangerous drug. The second one is the accused has custody and control over the dangerous drugs. The third is weight of the dangerous drugs exceeded the permitted limit. The fourth is the accused had knowledge of the nature of the dangerous drugs. Evidence must be adduced in order to prove these ingredients. In pursuant to Section 37, subsection DA of the Dangerous Drugs Act 1952, if all the ingredients are proven, the court can make a presumption that there is an intent to traffic.
It is actually very tough to prove trafficking because in some cases, the investigating officer might ambush or arrest the accused person prematurely. This is because transporting a large quantity of drugs from one location to another does not qualify the accused as a trafficker. As a result, the prosecution bears the legal burden of demonstrating that the accused intended to transfer the drugs to another person in order to establish trafficking. And to limit reliance on statutory presumptions, the investigating officer must find and use more concrete evidence. The mens rea of drug trafficking is when the accused person is found to have custody and control over the drugs. And in order to establish knowledge, the court would consider whether the accused's actions were sufficient to infer that they was knowledgeable about the drugs in question.
There are 2 cases that can be analysed regarding the drug trafficking issue, which the first one is public prosecutor against Tukiman bin Demin. It must be noted that the court must be satisfied that the accused had exclusive possession of the dangerous drugs to sustain a conviction for trafficking, and mere possession alone would not suffice to convict. In this case, the court held that exclusive possession means the place where the drugs were found must be exclusive to the accused. However, the possession of drugs need not be exclusive. Therefore, for possession to be established, accessibility by others to the place where the drugs were found must be excluded. Briefly, the court held that mere existence of the drug itself is not sufficient to constitute control over the drugs. Moreover, once custody and control of the offensive drugs is proved, the trial judge in a drug trafficking case is left with no discretion not to invoke the presumption under Section 37D of the DDA, whereupon the onus of proof shifts to the accused to show on the balance of probabilities that he had no knowledge of the drugs and of the nature of the drugs. If the accused could prove in rebuttal of the presumption that he had no knowledge of the drugs on both counts, he would be acquitted outright of the trafficking charge despite being in physical possession of the drugs. It is contrary in the case of Satya Velu against public prosecutor, as the failure on the part of the accused to rebut the presumption of knowledge under Section 37D must mean that the presumed knowledge of the presence of the drugs and of the nature of the drugs became actual proof of the facts presumed. It became truth that the appellant knew not only of the presence of drugs, but also that there were dangerous drugs. Hence, the appellant was charged with 2 counts of drug trafficking charges as he failed to rebut the presumption of knowledge under Section 37D of the DDA whilst having custody and control of the drugs. There are 4 relevant domestic drug laws in Malaysia. The first one is Dangerous Drugs Act 1952, the main drug law in Malaysia which regulates importation, manufacturing, selling, possessing, exporting and usage of all types of drugs. This act also specifies punishment for drug offences, including the death penalty for drug trafficking. Secondly, Dangerous Drugs Special Preventive Measures Act 1985. This regulation offers powers to the executive to hold a drug trafficker for up to 2 years at a time without going through the procedure of a court of law. This act also allows the Royal Malaysian Police to detain a person for not more than 60 days for drug-related crimes. Thirdly, Dangerous Drugs Forfeiture of Property Act 1988. It gives authorities the power to trace, freeze and confiscate drug traffickers' assets, and the onus is on the culpable individual or drug trafficker to establish that his property was earned legally. And the last one is Drug Dependence Treatment and Rehabilitation Act 1983. It focuses on drug rehabilitation, which is under jurisdiction of RMP and Narcotic Crime Investigation Department. Also, the National Anti-Drug Agency (NADA) made treatment and rehabilitation services by opening Cure and Care One Malaysia Clinic as an alternative to mandatory drug treatment, which involve arrest, court order, and legal consequences, and recognized as a regional best practice.
As for the suggestions, to tackle this plight, more initiatives must be rigorously designed and implemented in order to get rid of the roots of the syndicate. Cooperation among international organizations and regional counterparts is critical to combating illegal drug trafficking in Malaysia. The RMP, notably the NCID, have to continue collaborating with international authorities to combat illegal drug operation in the country. Therefore, it is essential to strengthen intelligence, law enforcement, and drug detection capacities with the goal of identifying and destroying drug cartels in Malaysia. The conclusion is, despite Malaysia's extremely harsh drug regulations, it does not seem to have been efficient in combating the drug plight. The depressing trend of continual rise in drug trafficking is evident in all available data. Thus, it may be inferred that the nation's current drug policies has been ineffective in combating the nation's drug issues.